Next week. No, I am. It is my appeal. I am just saying, let it be next week. Next week, it can be sent to next circuit.
Anyhow, not this week.
Not this week. I will not come in the way. Next circuit, next week is fine. Item 2, WBCP 31 of 2023.
Here, Your Lordship, the only point is that the tribunal rejected my application on the ground that the persons who were given appointment, they were having higher qualification and therefore they have been given appointment. And the petitioner hearing, he doesn't have the qualification. That is the fact which has been observed by the tribunal. Kindly come to the operative portion. 114, paragraph, page number 114. It can be seen that the applicant was not duly qualified at the time of their initial engagement, whereas the other teachers who were subsequently regularized were in fact duly qualified at the time of their initial engagement. The reason assigned by the respondents has not been rebutted with any corroborative materials or evidence. In absence of any such material, we do not find any such reason to interfere with the speaking order. Now, Your Lordship, I can show from the documents itself that those persons were also not having the requisite qualification as prescribed by the authorities. They were not having. That is the reason why when the appointment was given to those persons, the authorities have relaxed the qualification and then appointment was given.
Where is that?
Yes, Your Lordship, just a minute. Page number 92.
Order number 2283.
Yes, Your Lordship. This is the order whereby those persons were given appointment.
Correct.
Now, Your Lordship, the operative portion, I am placing it. We can go through the entire one, but I'm just placing the.
Relaxation is granted in terms of the qualification and age.
Yes. Now, Your Lordship, kindly see here. The last paragraph of page number 92. And whereas during appointment of Janki Devi and Jiva Rani, the recruitment rules of PST did not acquire CTET pass. In fact, all 5 applicants of OA are MA BA pass, whereas Janki and Jiva Rani were only 12th pass and JBT. Thus, it affects candidates with higher qualification got left out. Subsequently, RR were amended and required passing of central teachers eligibility test was added and upper age limit was fixed at 30 years, due to which these candidates became ineligible for the post of PST as per prevalent recruitment rules. Not only that, these people are not even having JBT. They were having B.Ed. Now, Your Lordship, I have decisions of the Honorable Supreme Court. JBT is not equivalent to B.Ed. If somebody has got B.Ed, that doesn't mean that B.Ed is the higher qualification of JBT. So, therefore,
What is JBT?
Junior Basic Training, that is Diploma in Education.
Okay.
And B.Ed is Bachelor in Education. But even then, Bachelor in Education is not equivalent to Junior Basic Training. That is for primary school teachers. JBT is for primary school teacher, and B.Ed is for GTT and PGT. So, Your Lordship, they have given a relaxation with regard to the qualification also and age also, and appointments were given, which is at page number 95. This is the appointment which were given to those 5 persons to the post of PhD, primary school teacher, and their qualification is specifically mentioned. Page number 96, qualification may be seen.
MA BEd, MA BEd,
Or MA BEd. Now, post is given, page number 95, primary school teacher.
Yes.
So the fact which has been on the basis of which my application was rejected, Your Lordship, that fact is not correct. Reasoning is not correct.
Yes.
So my submission is that this matter has to be remanded to the tribunal.
What is the essential qualification?
JBT or Diploma in Education with class 12 or PhD. That they will not dispute it also, and they are observed in the speaking order.
Where is that speaking order?
Yes.
16 December order?
Yes, Your Lordship. It is set out in that order of the tribunal
No,
also.
no, this is a 16 December order,
Yes, 16 December 2022.
page 104.
Yes,
This is that speaking order.
yes, speaking order.
What? It's only the 4,000 rupees per month. That is the only salary.
That time, Your Lordship, when tsunami was there, that time they have helped them voluntarily. So that amount was fixed, 2,000, 4,000 like that. And decision was taken by the
Now,
authorities.
now you are in Barjan, in
Yes,
Barajan.
in Barajan.
In Barajan. And these 8 persons, you are not here.
No,
You acquired JBT qualification during 2000 year,
2012.
2012, sorry.
Yes.
They say that there is no qualification, there is no document that you have qualified CTET.
Even those persons have also not qualified CTET. None of them. That is the reason why relaxation was given with regard to qualification.
And when you started doing it,
Your Lordship,
when you were engaged as a volunteer.
2005. 2004, 2005, Your Lordship. I have the orders.
But he says that your qualification comes in 2012 only.
At least my qualification has come in 2012. Those 5 persons who were given appointment, they are not even qualified. They don't have JBT,
And not CTET also.
not CTET also. So that cannot be the reason I am saying.
Yes, that's the only point.
That is the only point.
Yes.
Yes, one of the speaking order specifically records that only these 8 people made the essential qualifications.
How?
And the rest of the candidates, which would include my learned seniors client, they were only holding the qualification of 10 pass, 12 pass and BA pass.
No, that
And
10, the minimum qualification is 12 pass.
12 pass.
yes, so
Over 12 pass.
no, my lord must see over here, it is recorded, the qualification is there.
Yes,
The rest of them had JBT or they were MA BEd. And
yes.
this
So
person
now-
became JBT only in 2012.
The question is, what is the criteria for under the recruitment rules?
My lord.
If it is a JBT is one of the essential qualification
Yes, ma'am.
and the CTET is also the another qualification, then even if they have acquired the higher degree, there's a question of acquiring a higher degree. Whether they would qualify,
That
that is
Yes.
conspicuously absent, and this is why you relax the age and also the qualification.
there,
Thank you.
my lord, the answer is that the Lieutenant Governor has the power to relax as a class. So in this case, all these people were MA BEd. So as a class, relaxation has been given to them. That
Maybe is an intelligible difference, yeah.
MA
If
BEd
they
and
slightly visualize, then it's a dangerous proposition that would come. That if the minimum qualification for a particular post is class 12, if then irrespective of the fact that somebody is a master graduate, master degree holder, the minimum qualification should be taken reckoned. You can't say that they are higher qualified, then you make a class distinction, that you can't do that.
No, my submission, my lords, is that let us accept whatever my learned senior has submitted. So therefore, all these 8 people were also not qualified. She was also not, I mean, Mr. Imberjan was also not qualified.
Correct.
Now, the only way in which this requirement, the qualification can be relaxed is if the Lieutenant Governor exercises his
But
discretionary power.
that should be
Yes.
rational, that should be reasonable.
Yes, sir.
He cannot do a pick and choose policy
Yes.
and then make a classification that somebody who is having a bachelor degree stands on a different class is of a different class. One having a master degree is a different class, and one having a class 12 degree pass certificate is a different class. If the minimum qualification is called class 12,
So, my lords, this power.
can it be done?
Yes, well, under that particular rule, the relaxation can only be given to a class of people. It cannot be made for an individual. In fact, last time the division bench had taken up this issue. If my lord has it on Monday, I can produce that judgment on this very issue of power of relaxation under fire.
No, that is true. I am not at all joining an issue on this point. What I am saying is that yes, the power to relax is conferred upon the Lieutenant Governor, no doubt. Now the question is how that power is to be exercised. If the power appears to have been exercised in a discriminatory manner, can that power be
No, I am
It's said to be
submitting my
correct.
lords 2 submissions. First, there is not discrimination because
Well, why not?
maybe it cannot be said.
That is what I'm asking. Then you could have said that the preference would be given to a candidate who has the higher qualification or a master degree or a bachelor degree. I can understand if the rule says so. In many recruitment, even when we also undertake this recruitment process, then we indicate that the preference. If they stand on the same footing, then the preference would be given to them who have a higher qualification. No doubt about it, but you do it. What you say, the rule does not say that there will be any preference or extra marks or anything is extra points will be allotted to a higher degree. If the minimum qualification is 12 and you have relaxed the age, you have relaxed also the qualification means that if they do not have a JVT, or they do not pass the CTET examination. What is this examination? So you relax it and then you say that I am picking up those persons.
My lords, a class is created of people who are highly qualified and therefore relaxed, my lords.
Can it be done? Show me, because I do not find a judgment in this regard. Yes, Article 14 says equality must be there, but there is a reasonable classification within the class is permissible.
Yes, my lord.
No difficulty. But there should be rationality, reasonability, and overall is an intelligible difference here. You have to say that how you have made them a different from others.
That, my lords, is speaking of recorded.
Not recorded. This is not a intelligible difference here in that regard.
Highly qualified to the post.
Highly qualified means what? It's an educational qualification. And the JBT is that the technique or the tools which are being imparted to these persons to train these primary students.
My lords, 12th pass and MA BEd, my lords, there is.
Primary school, what do you teach? What do you teach? You
Not
just
similar
you
to
just-
these people. 12th pass and MA.
No, it's a skill how to impart education.
But
It's a skill too of primary. I can understand it's a higher, say in the class 9, 10, higher classes, I can understand. 11, 12, you need some persons who is very good. But primary
But where in a situation where both of them
is
don't have the,
elementary education you are doing.
where they do not have the eligibility criteria, both of
What
them
is
don't
that?
have-
I am again saying, if they are class 12 pass, eligibility criteria is this,
Yes, sir.
that a person must have class 12 pass certificate.
Yes, sir.
She is qualified.
But no.
Now, she is qualified. She is eligible to sit in the recruitment process. You can't deny that you can't. The second factor is that if you have said that the JBT is one of the another essential conditions, mere 12 pass will not do, JBT has to be there. Or you must also qualify CTET examination. These two qualifications are attached to it. Then it is irrespective whether a person has a bachelor degree or a master degree. All will have to qualified JBT and CTET. And if you have relaxed for them that no JBT, no CTET, I am relaxing it, then why you will not relax for class?
My lords, I produce the judgment, my lords, may have it on my.
Sure, I don't think so. If
I'll
my view is very firm on that, please show us. If I feel that I cannot persuade myself to agree, I will refer the matter to a larger way. But the relaxation can be done in this fashion.
I'll produce.
Or if I get a Supreme Court judgment on that
My lord,
score, then that is more binding on us.
my lord. I will do.
Show us the judgment. Let them show a judgment.
Let it be on Monday.
A point is taken by the petitioner that there is an apparent act of discrimination at the behest of the respondent authorities in extending relaxation with regard to the qualification as well as the age. But deny the relaxation to the petitioner, though he or she what? Though he stands on the same pedestal. A point is taken by the respondent that the persons who have been appointed to the post of a primary teacher were having a higher educational degree, and therefore the Lieutenant Governor, in exercise of power of relaxation conferred under the statutory rule, created a class which is distinct and which is distinct which is distinct and distinguishes the other candidates. To stop. However, the respondent says that the division bench of this court has accepted the said view and found such classification within the class to be reasonable and intends to rely upon the said judgment on the next date. In view of the above, let this matter be placed on Monday.
Your Lordship, item number 3, Your Lordship, I am seeking time till Monday. Monday may be taken.
Twice I have read this brief.
Your Lordship, Monday. Positively I will do.
Now I will forget by this time. Not this week. On the prayer of the petitioner, let this matter be listed on Monday.
Item number 4 and item number 30, Your Lordship. They are similar matters, so it can be taken up, Your Lordship. Retired employee, Your Lordship, they are
30
separate.
is the hearing matter.
Yes. Both are same matter, practically.
There's a point of distinction that one is working, the other is retired, but the legal issue is the same.
Yes. My client has retired, Your Lordship,
My client also retired.
by this time.
Out of 10.
Vijay Kumar is retired, the other person is working.
नहीं, इनका हुआ है.
Here, my lords, my
What is the order of the tribunal?
page 19,
19
Yes.
and 90
19.
of Vijay Kumar?
Paper book is there, my.
Oh,
ये कौन सा file दिया?
One thing, Kasim.
V Vijay Kumar, yes, sir. Page 19 of this.
this is the nature.
And that is the
Next page.
covering that.
What is the matter about?
Well, this is a case where, my lords, contractual employees, my lords, they were regularized. So initially, when the regularization happened, the service benefits which would be relevant for the purposes of say pension, etc. That was given from the date of their appointment.
From the date of regularization or from the date of admission?
Now, subsequently, an audit query was raised saying that this is incorrect. And so therefore, the administration revised it and they said, no, it should be from the date of regularization. And that was challenged before the CAT. And the CAT has held in favor of the employees, relying on a Supreme Court judgment in Parimal Haldar's case, saying that there the Supreme Court says that if the employee is appointed not against fixed pay, but against scale pay, grade pay, then in that case, this benefit can be given to them from the date of their appointment.
Yes.
These employees admittedly are also appointed against grade pay. There is no factual distinction, but pay scale. Correct. Thank you. But I'll try to endeavor because there are other judgments also. My endeavor will be to say that it should be from the date of regularization.
Sure. First, give me a Parimal Haldar's judgment.
Yes, sir. I've got Parimal Haldar. I'll just.
It's there in my paper book, Milad, page 51.
Page 30, item number 30.
I've got spare copy also. If that is convenient, I can.
Let's give me a spare copy first.
इतना दो ये दे दीजिए आपको चाहिए क्या
Yes.
I've got one judgment of the Supreme Court which I seek to rely upon.
The extra copy.
This is the judgment.
Contractual scale नहीं है ना, applicable नहीं है। Adopt है plus हम लोग scale, इसमें scale के बारे में कुछ नहीं लिखा।
What is the ratio of this judgment? Nothing.
No, no, sir,
Absolutely on consent.
that's My humble submission
You
is.
want consent, this was
Oh, I
passed.
appreciate, madam. My humble submission is only this, that it is one thing. So I am only making a humble submission, my lords. My submission is, it is one thing to direct that the administration will not recover because it is for earlier periods. That recovery, but to say that they will be given going forward also all the benefits will result in a tremendous burden on the exchequer.
No,
So my lords, that my lords may decide, my lords. I can only submit to an extent. On that.
No.
The request is my.
Because the Parimal is very categorical. It says on a pay scale, you have to give it.
That is right. But only submission is, my lord, that if, my lord, some reasonable time may be granted.
Very, I think with a note of caution, that since they have never claimed any seniority on the basis thereof, they will not claim seniority. So they will not claim seniority in
question
that.
that doesn't arise, your lordship. We have retired, but
Once,
retired employee.
Sometimes it so happened that I was entitled to be promoted
Yes, yes.
automatically.
No, that is not a claim also. Our claim is
just
not-
there is a direction in the CAT's order to.
And after my retirement, your lordship, they have changed the order. After the retirement.
So at page 24, not even before, the operative part says release due amount payable to the applicant, my lords, reasonable time may be granted, my lords.
How much?
As much as, my lord, I can request for 1 year.
Already retired people.
8 weeks at least, my lords. 4 months will be required, my lord. My instructions are 4 months.
16 months.
That's why I am requesting for 16, my lord. We grant less than that, I am quite certain.
Not more than 2 months, your lordship. 2 months they should give. We are retired people, your lordship.
They are getting provisional pension and over ₹1,00,000.
Correct. You have been fighting since when?
Since 2022. October
So
2020.
now we are at the fag end of 2023. So 2-3 months, 4 months will not change any scenario. Ultimately, you will get the benefit.
Your lordship.
Only one submission I would like to make. I laid upon another judgment. It is there in my paper, page 54.
Burdening us.
No. Just I want to submit before the sample. Page 54.
I've got spare copy if my lord wants. Spare copy should I give?
No, I got it.
Proceeding वाला matter.
This is. I don't know what.
That was on a different note.
Same ad hoc service.
Here, no.
That is on a different note. Question is different. The question is, in this case, which you are relying, the question was that they were on an ad hoc service for continued service for 30 years. And then when they retire, they denied the pension and other benefits. Then the court says that you have utilized their services for more than 30 years, maybe on an ad hoc basis. How can you deny that those the benefits? The court has taken a very, I think, a very reasonable view in this regard and says that you extend that pensionary benefits to them. But here is a case that when it should reckon.
Yes.
It should be from the date when the contractual appointment or ad hoc appointment was done, or from the date of regularization. The Parimal order is very categorical on this.
As they have been
That
appointed.
if they have been appointed, so that can be.
And
Your
admitted
client is
that-
present.
Miller?
Your client is presented. I just thought that unless
No,
you.
sent through video.
Oh, I just thought that
It's alert now.
unless you open your mouth, you will not be benefited what you expect. So I just
It is
thought.
there, my lord, I placed the judgment before the tribunal. So it is my duty to place it before your lordship.
Both the writ petitions are taken up together, involving a common question of law. Full stop. The center of debate the center of dispute relates to the refixation of a pay at par with the other similarly circumstanced persons. The petitioners were appointed on a ad hoc / contractual basis. In 1988, 1988,
1988.
Yes, yes.
it was given from 1988,
Yes, 1988.
from on in
14 July.
in the year 1988.
Pay scale also can be mentioned. Pay scale also can be mentioned. It is mentioned in the order
At the pay scale of,
1640-60.
where do I get it?
Your Lordship, page number 12 of the paper book.
12.
12. Your Lordship is looking to the paper book.
Vijay Kumar.
Yes, yes. Page number 12.
Yes.
Page number 12.
Where?
Fifth line, 1640.
No, I do not get it.
Achha, 42. 42, Your Lordship. Actually, the inner page is 12. That is very bold. 42, hai na? 62. 301.
He was appointed. Was appointed on 14 June 1988. On ad hoc / contractual, what I said, contractual basis.
Yeah, only ad hoc is mentioned.
Ad hoc basis.
Yes.
To the post of a veterinary assistant surgeon
Yes.
within bracket Group B
Group B.
at a basic pay of rupees 1640 per month. In the scale of pay of rupees 1640-60-2600-EV-75-25-2900. For a period of initially for a period of 6 months in the Animal Husbandry Department, Andaman and Nicobar Island. The petitioner continued to render such services uninterruptedly until the administration decided to regularize their appointment / services, which in fact was done on
You know, that
regularization.
I'm giving the date. Just a minute.
4th May 1998. 4th May 1998.
4th May 1998.
Basically.
सब एक साथ दिए ना सभी को।
What are you talking about? 4th May, adult appointment is 14 June. And May appointment 88.
Well, UPSC.
98.
98. He's saying 88.
No, 98.
98. 4th May 1998. The dispute arose
Appointment order was actually issued on 22nd July 19. The recommendation was 4th May.
UPSC के recommendation.
UPSC's recommendation was 4th May 1998 and order was passed by the authorities on 22nd July 1998.
I would have said. Their services and adults, their services. No, that should be on 22nd.
22nd July 19.
Clear bhi.
On the basis of the recommendation of UPSC dated 4th May 1998. Right. The dispute arose on the basis of an impugned order dated 19/1/2022 passed by the administration, refixing the pay of the applicants the said decision was received before the the aforesaid order not only covered the petitioner but the similarly circumstanced persons, some of whom challenged the said order before the tribunal in OA 353 of 2022 and OA 354 of 2022. And by a common order, the tribunal quashed and set aside the decision of the administration relating to refixation of the pay and directed the administration to consider the date of appointment to be on a date when the respective petitioners were appointed on an ad hoc basis. The similar point arose in the the similar point arose in the instant matter, where when the authorities, when the administration decided to give effect to the benefit of the scale of pay or a grade pay from the date of regularization of their ad hoc services, and not from the date when they were appointed on ad hoc basis. A plea was sought to be taken by the administration that during an audit, it was pointed out by the auditor that giving benefit of the scale pay scale from the date when the person was appointed on an ad hoc basis is impermissible, and on the basis of the recommendation thereof, the pay scale, the scale of pay was refixed by the administration, and the benefits attributable to the posts was extended from the date of the regularization. In an identical case, of Parimal Haldar, the matter traveled to the Supreme Court. In the said case, it was in the said case, the identical issue was raised when the administration decided to refix the scale from the date of regularization and not from the date of the ad hoc appointment. The apex court in special leave to appeal within the civil number 31187 of 2013 decided on 13 January 2015 held that the moment the petitioner was appointed on a pay scale and not on a fixed pay, there is no justification in the decision of the authority in revising the pay scale from the date of the regularization and not from the date of an ad hoc appointment in the following quote from this paragraph on the first glass. And up to the ad hoc basis. I have quoted that. However, the learned counsel for the administration intend to rely upon another judgment of the Supreme Court rendered in case of North Delhi Municipal Corporation versus Hagleen Kaur and others, reported in 2019 SCC Online SC 1907, that reported in such and such. Yes. Wherein the contractual appointees were working since 1997-1998. And on the conversion of the post, they were allowed to continue to render such services with a view to outbreak a dengue. Stop. The claim was made by the applicants therein that since the post have been created, though by way of a conversion, they are eligible to be regularized at the said post and approach the tribunal seeking a substantive order for regularization. Obviously, the tribunal declined to accede to such prayer, taking note of the judgment of the Supreme Court rendered in case of State of Karnataka versus Uma Devi, reported in 2006, volume 4, SCC 1. Stop. The apex court did not interfere with the said order, but was of the view that the consequential monetary benefits which is claimed by those appointees from the date of their initial appointment on ad hoc basis should be extended from the date of the order of the tribunal. Obviously, the regularization was not done and so far as it would appear from the said judgment that the plea of regularization was not gone into by the Supreme Court in view of the decision rendered in Uma Devi within bracket 3 within bracket Supra. But so far as the monetary benefit was concerned, the apex court found that it should be from the date of the order of the tribunal and not from a date anterior thereto. The point involved in the said above noted judgments was different and not the one which is involved in the instant writ petition. The point which arose in the instant case is whether the fixation of pay can be revised by the administration to give effect from the date of regularization or from the date of an initial appointment on ad hoc basis. The apex court in case of Parimal Haldar, as quoted above, was considering the aforesaid point and held that the moment the applicants are found to have been appointed on a pay scale and not on a fixed pay, revisitations and or refixation of the scale of pay from a date of regularization is untenable, and therefore we do not find any difficulty in accepting the ratio laid down in the said judgment to have its applicability herein. Even a tribunal has also relied upon the said judgment of the apex court and extended the benefit, which cannot be said to be infirm and or illegal or contrary to law. Accordingly, the writ petition is dismissed, no order is to cause. However, we appreciate the submission of the learned advocate for the respondent that because of the pendency of the instant writ petition, the time fixed therein has elapsed, and it would be an undue hardship on the administration if the such time period is not extended, as the consequence for non-implementation of the said order has a far-reaching effect. In view of the above, we therefore extend the time as granted by the trial court by 4 months. So, save to the extent of enlargement of the period, the other portion of the tribunal order is not interfered with.
Obliging.
Quote. You quote from her. If you want this one. Call the names.
WPFP 9 of 2023. I put the petition.
Why this matter was not taken up yesterday?
Because service was not.
Service was fine. You have done that. Yes, lot of accidents are really happening. This is that case. So why not take care, because he has given a list of the accident between 2022 to 2023.
Only 6 months. Duration 6 months.
This is to be taken into account. No, I do not know this 279 and 337. Yes.
Yeah.
Hey, give that IPC to me.
Fires have been lodged even as per the.
I would explain my kitchen.
FIR has been lodged. Accident cases also.
Rash driving. 279 is the rash driving.
करना पड़ेगा.
So these are all the incidents of rash driving. 279 is the rash driving.
You receive 304A.
No, 337.
Injury.
In most of the cases, 337 is in causing hurt by act of endangering life or personal safety. And these are all bailable offences, 6 months. So if there is a vehicle which is flying on the road, you don't know.
Let's say
But if there is a fatal, I can understand. If there are fatal accidents,
all of the
which
fatal,
are the
14 fatal, they are wearing all the grip.
every day there are as many as hundreds complaints which are there under section 275. Hundreds every day. Only thing is, the difficulty is that they have not set up the speed limit that no vehicle should fly or should go beyond that particular speed limit. If that is done, then you can book it in this. But I do not know in the island whether any speed limit is fixed by them. In other part of the country, I know the speed
In
limit is
fact, there
given.
are certain measures, for example, the cars, commercial cars like rented cars, etc. They have a chip which is put in the car which prevents the car from speeding beyond a point. So steps are actually taken. I can.
Nowadays, it is says that sometimes the 60 kilometer per hour, sometimes they fix the limit. If somebody
Yes,
exceeds, then it started beeping.
Steps are taken. I can place it on affidavit, but they talk about a representation which is not annexed with the writ. So I don't know. The 19th August 20 is saying there's
You will see.
representation to Lieutenant Governor, but that is not annexed.
Please see page 8.
They have given a representation. The mass representation is given.
Mass petition is there, and you are denying that.
Okay, I'm sorry. Yes, of course.
Mass representation
Yes,
is
no,
there.
I got confused. Yes, it is there.
So something has to be done. I think the organized, the vehicle movement, there should be some kind of a drive you should take out. Awareness, not only the awareness, but also there should be a check and balances. Adequate personnel must also be deployed at the relevant places to check.
Because either we can file an affidavit if it comments to your lordship, or this can be treated as a representation. We can dispose it of. So our defense is not before lordship.
This is the continuous monitoring is not required. They have to take an adequate steps in this regard, because I do not find those cases are of. It is quite natural that somebody who has just crossed the limit, then you say as well. So these are all.
So whether steps are taken or not, that my lords, I'll have to file an affidavit, my lords. Otherwise, this can be treated as a representation.
You know, see,
I don't know what
the
judicial
mass
inquiry
petition was filed on 19/8. Now I am on 29. Within 32 days, he has not taken any step. What is that rampant and lethargic attitude of the respondent?
This is not the address to the Lieutenant Governor, my lords. There are so many cases that representations have not been. We are not living in utopia also.
The Lieutenant Governor is the highest authority. He is an administrator of the entire UT territory, Andaman and Nicobar. He is the administrator, appointed by the president, honorable president of the country. So it is not expected. When it has reached to him, at least there should be some kind of a response that should come, either routing or rerouting it to the particular department. I think
Must have been done, my lords.
it should have been done from their secretariat. Something has to be done.
19th August is just 1 month.
You not see.
I don't know.
They have given certain suggestions.
Yes, my lord.
And they wanted that if there is a speed breaker, at least they can check that particular speed because the rash driving are there.
Deployment of traffic
Rampant
police.
cases are being done, registered for rash driving.
Certainly.
279 is for rash driving. So you can do it,
Yes, my lord. But
speed breakers and all everything.
That we
I
have
know.
to.
Deployment,
Zebra crossing has to be
no,
given.
your lordship, deployment of the traffic police, there are traffic posts, but police is not there.
oh, if these, I'm only submitting that my lord is absolutely right, but if it is being done, I will have to file it on affidavit whether the steps are done.
Your lordship, within 2 days and 3 days.
No, that is not possible because we have to ascertain, because even if there's the speed limit, the speed breaker, suppose a car is running. at
It is not a matter of
80,
If
speed
very
breaker
large
suddenly
matter,
comes,
very-
he knows that
it
there
is
is there
not
are
matter, it may be
accident.
within 2 days and
No, no,
within 3 days.
This is not fair.
As a.
This is not fair, my
lordship,
lord. No, no, just because it is
Within
just Thakur's matter,
within
it
this,
cannot be done.
within this session,
No, no, my lord, this cannot.
otherwise they will going to.
There is a barricade. There, what
And they
is
will not-
explained by police to me, there is a barricade, now people are ignoring the traffic law, they are crossing the barricade. What can be done?
Energy level. The senior was very modest in his submission, the junior becomes so agitated, so energized. That he toppled the senior and then started.
No, my lord,
I apologize for that.
my lord, the problem is it cannot be, what is this 2 days, my lord? There are so many matters, my lord.
Have the prince said anything on
No,
that?
because I am responding to his submission, my lord. Every matter of Mr.
You will
Thakur-
respond to the queries of the court.
Yes, yes, my lord. That is why, my
That's
lord,
all.
I was not saying anything.
Means. The petitioner being a public spirited person and the resident of a locality raised an issue relating to a rash driving causing body injury to many of the commuters and the resident of the locality. And have taken up the responsibility of filing the instant PIL application, PIL on behalf of the other residents. The mass petition was also addressed to the Lieutenant Governor on 19th August 2023. Till date, no steps have been taken in this regard. The details of the cases registered under section 279 with other charging sections between the period from 2nd January 2022 till 15/4/20 till 18/7/2023 are also disclosed in the instant PIL, which shows that there is a rampant surge in violation of the traffic laws. And because of the rash and negligent driving, the safety and security of the life has also been put in danger. The respondent have taken a serious view in this regard and showed their sensitivity to the cause and submitted before the court that they have taken all adequate measures which are required to curb the offense to be committed under the vehicle law, under the motor vehicle law. And if further steps are required to be taken, the authorities are sensitive about it and shall take all such adequate measures to stop. However, it is submitted that the steps which are already taken and proposed to be taken can be brought on record if the respondents are permitted to disclose the facts by way of an affidavit. Be that as it may, it is a duty of the administration to see that the drivers of the motor vehicle, the drivers of the motor vehicle do not violate the traffic rules or the laws applicable in this regard, and ensure that timely intervention is required, and ensure the timely intervention thereof, if necessary, by taking into account the suggestions given in the mass petition dated 19th August 2023. Let this EIL be made returnable before the next circuit bench. The respondents have filed an affidavit within 2 weeks from date.
And you guys.
Your next question. Matter was argued yesterday.
What is this?
Which was argued, this is that matter which was concerning the issue of promotion, that ratio of direct recruits and
Oh, this is the 50% and the
Yes, yes,
50%. I
Replace
could not,
something.
I took it, I could not go through it.
my lord,
Can I keep this matter on Monday?
my lord, my lord,
I'll come on Sunday and then do it.
my lord.
Give it on Sunday. Give it to me on Sunday. Keep this matter on Monday. Yes,
Next two matters, for the petitioners, let these two matters be on Monday if possible,
which one?
41 and 42,
7 and 8.
7 and 8.
Item 7.
Oh,
if
yes,
possible.
yes, not today, no difficult.
I am obliged by it.
Yes.
For the respondent bullets.
Oh,
I pay for the appellant, my lord.
yes, sir.
My lord, I have another point of
Oh, not on that point.
that point on stamp duty when not paid along with the agreement. This agreement is cannot be accepted, my lord, in the arbitration.
You are relying on NM Global.
Yes, my lord.
2023, volume 7, SCC, page 1.
My lord.
Oh.
Yes, my lord.
Dissenting judgment 3:2.
Yes, my lord.
So you were arguing dissenting judgment has to be considered. So we will consider the dissenting judgment. You were arguing
Yes.
yesterday
Yes.
that one of the arbitrators has given a dissenting judgment. You should consider this dissenting judgment. So here also two of the honorable judges has given a dissenting view.
My
So
lord.
we consider that this dissenting view.
My lord, here I pray that
So we consider that.
majority judgment may be.
Now you say majority.
My lord.
Then award majority. Then you'll have to accept that point also. Same thing. So choose what you say.
Right. This point of law, my lord, that I agree that majority has to be
So
Deal.
now you agree this.
my lord.
Now, yes, good. Now,
That,
tell me,
yes, sir.
You have cited a judgment on the score
My lord.
that if the agreement which requires an stamp
Stamp
duty
duty.
to be put in,
Yes, my lord.
having not put in or insufficiently put in,
My lord.
then that agreement cannot be received in evidence
My lord.
unless impounded.
My lord.
And the law says that it can also not be acted upon
My lord.
until it is impounded.
My lord.
The court, the majority view has gone to that extent, which says that it will remain as a void until that impounding is done.
My lord.
Yeah. What about section 36 of the Stamp Act? Give him a section 36 of the Stamp Act. Stamp duty, that will be a Stamp Act, yes.
Admission of instrument were not to be questioned.
Hmm. Hmm. Yes.
Where an instrument has been admitted in evidence, such admission shall not accept provided in section 61 be called in question at any stage of the same suit or proceeding on ground that the instrument has not been duly stamped.
Can you now, after everything is over, at this stage, can you take this plea? I am asking you.
My lord, this is a law.
Agreement has been accepted and received in evidence, though should not have been unless impounded. Can you raise an issue now?
Yes, my lord, before this honorable court, High Court, I can.
Tell us,
My
sir,
lord,
then what is the meaning of this section 36? Why section 36 is introduced? Dr. Nithi gets it. But 36 to 5 also. And you did not raise this point, sir, at any point of time. You are talking about is a pure question of law.
My lord.
But look at that section 36. Can you raise the plea now?
My lord,
Is it not a bar or embargo which is created?
Law point can be raised at any stage. My lord.
Look at the law point. Section 36 talks about that you cannot raise it at a later stage. If there is a bar under the act itself, then can you raise it? I'm asking you.
Court can examine at any stage. My lord.
Then what is the utility of section 36, sir? Then we'll have to say that 36 has no application. 36 has to be.
Under 33 of Stamp Act, the court has to.
Now, second question.
My lord.
On a question of interpretation of the statute. If there are 3 sections in the statute itself, same act. And it appears that one section is somewhat contrary to the another section. Then which one should prevail? The earlier section or the latter section? I am asking.
The court is free to take, because it is the matter of the revenue to the government, and court has to protect the revenue for the government.
কি করবো বলতো? হুম, হুম। Yes, sir. Tell us. Very interesting distinction is there between having been involved. It's produced or comes performance of these persons. If adhere to this perspective, student is not reduced information. Court has an authority to receive the documented knowledge and to deputy the understand. This is the response. What the 35 is. No instruments are given in this case that we need to do marketing for any particular by law or any party to receive evidence. I feel like that. Was pages work happening shall be up to the bond. এখানে একটা নতুন বল pages workটা আছে up to the bond মানে হচ্ছে at this initial stage of involvement, at the initial stage or whatever. Tomorrow into love after the point that you have to go the role. If the chips are particularly into past of 36. Then after the point, what does
My lord, 7 of the Arbitration Act attracts, my lord, that if it is insufficiently not stamped, it cannot be acted upon. Section 7 of the Arbitration.
Hey. Arbitration and constitution. Yes, sir. Yes. Where does it say, sir? The language of section 7 does not talk about not to be acted upon. Never.
Agreement.
Only is a form of that what should constitute an arbitration agreement. It may be by way of a separate agreement, it may be by virtue of a clause in a parent agreement, it may be by way of telex, letter, whatever, the electronic means, email, WhatsApp, everything has been included, which may provide a record of the agreement. But where it says it's a stamp duty,
It's not.
it is.
In
Yes,
this judgment paragraph 114,
yes.
it has said like that, my lord. An arbitral agreement within the meaning of section 7 of the act which attracts stamp duty, which is not stamped or insufficiently
That
stamped,
means
cannot be acted upon.
agreement as indicated in section 7.
My
So first and foremost thing is that it must be an arbitral agreement within the meaning of the same under section 7.
lord.
And then if that agreement, if the court is satisfied that it is an agreement under section 7,
My lord.
then if the court finds that it requires a stamp duty to be put thereupon, then the court will direct the document to be impounded.
My lord.
So yes,
That is one point, my lord. There are another point that the learned district judge has not applied his mind. So this honorable court can remand back for.
no difficulty.
My lord.
That power is reserved.
My lord.
Give whatever you want to say. On application number, obviously. No difficulty.
Regarding there is a office memorandum which says that all the commercial the concession contract has to be through escrow account. That has not been followed in this case.
That is what,
My lord.
that is what is there. No difficulty.
My lord can interfere with the award if the there is a contrary to the evidence. The award is contrary to the evidence. My lord can interfere. Here the evidence agreement is not a.
That is coming under the bracket of purview of perversity.
My lord.
No difficulty. Who says that perversity is one of the grounds where the
Yes.
court can?
My lord.
Saw pipes case,
Right.
ONGC. These are no problem.
My lord. In this case also the arbitrator has acted perversely, my lord.
Yes, anything more?
The all other points I have already taken in the
Yes,
appeal not been considered.
not being considered, will consider. Yes, what do you say? The respondent?
That's as far as my learned friend requested this court to remand the matter, but that provision is available only under 34(4). He should have made out an application before the learned district judge and not under section 37 before this honorable court. And moreover, his point for remand is that there's non-application.
Why not the appellate power? Why not it can do?
My lords, may kindly see the language used under 34(4).
Yes, tell us.
I'll just read 34(4).
Yes,
Receipt of an application under subsection 1, the court may, where it is appropriate and it is so requested by a party, adjourn the proceedings for a period of time determined by it in order to give the arbitral tribunal an opportunity to resume the arbitral proceedings or to take such other action as in the opinion of the arbitral tribunal will eliminate the grounds for setting aside the arbitral award.
correct.
Therefore, two things. One,
The question is not that the matter is remitted to an arbitral tribunal. The question is, it is to be remitted to a section 34 court.
There is no such powers, my lord.
Correct. So why not the appellate court enjoins a power even under order 43 rule 23, order 41 rule 23, order 41 rule 23A, order 41 rule 24, the definitely appellate court enjoins.
But if that may arise only, my lord, if the 34 court has not considered, my lord, the award in a proper perspective or has not interfered.
But I do not find any fetter in this regard. That the appellate court cannot remand the matter to a section 34 court. I can understand to the arbitral tribunal even then it can, because the appellate court enjoins only the trial that of the original court.
But if the 34 court has not considered not his case in manner known to law, then my lords may remand it. But please see the impugned order, my lord. The order.
All depends upon the facts of the case, whether it requires a remand. You raise an issue that it cannot be. So that my reaction is why not? If the proper case is made out, why not the appellate court can remand the matter?
My lords. The impugned order, my lord, is at page 2189.
Stamp duty over.
If, my lord, there is an error apparent on record by the 34 court, then my lords can remand it.
No, that is, I'm not. Now he is raising a plea of a stamp duty.
My lord, stamp duty, he is referred to NN Global. Now,
Yes.
NN Global is a case, my lord, where it was decided on section 11. At the first instance, when appointment of an arbitrator was made, then the stand was taken.
So can it not apply in section 9 proceeding? Can it not apply?
It can apply on a section 9 because that is also a first instance where the party approaches the court even before the award is passed or even before the arbitral proceedings start. And if that issue is raised, my lord, yes.
If there is an embargo, there is a bar which is created under the section. Can it not be taken as a ground for challenge?
But here is a case, my lord, the government played a first
Provision of the entire jurisdiction, and it really impinges upon the jurisdiction.
But first, my lord, whether this is understamped or not itself is a question.
Yes.
How it is understamped? It's stamped on 100 stamp duty of 100 rupees has been paid. And my lord, these agreements are not compulsorily registrable documents. This falls within the residue clause where
Registration is different.
yes,
And-
registration is different. The residuary clause only says rupees 100. At least in state of Tamil Nadu is only 20. Therefore, my lord, 100 is overpaid. My lord, this is clear fence sitting, my lord. He waits for the award, does not raise this in the ground under 34. Even yesterday, this point was not raised. This is not found in the grounds also.
Yes.
And my lord, the learned district judge, my lord, has considered each and every aspect of this point that has been raised. My lords will find his order between pages 2189 to 2199 of volume 9, exhibited as P22. Every aspect of whatever my learned friend has raised has been considered.
Yes.
And concluded, my lord, is not a fit case for interference. That is why, my lord, I pointed out to the Konkan Railways case. Even if there are two views possible, and if one view has been taken by the arbitral tribunal, and if that view is a reasonable view, a plausible view, then Lord's court refrains from interfering. It is not something, my lord, which is an award which is absolutely perverse. Now, the first argument that they took before the tribunal was the pre-bid documents does not form part of the contract. That issue was first considered. Then, my lord, they came to a conclusion all the pre-bid documents would form part of the contract. Then they went into the second issue of what type of an agreement this is, whether it's a concession agreement or an EPC contract. But evidence were let in by both parties, including the expert evidence. An ultimate conclusion was given, my lord, based on documents as well as oral evidence. And now for them, my lord, to turn around and say it is perverse. Now they have not shown on what ground the perversity is raised.
Yes.
Lords, may kindly, my lord, take 2189, my lords, of volume number 9.
That's true. We'll see to it.
Yes, my lords.
That's all.
And my lords may also appreciate, my lord, the other judgments that I've already filed yesterday.
Yes. We will take into account.
Yes, Madam.
Yes, thank you.
Obliged. Madam. Great.
Yes, uploaded. Hey, Patito. Yes, can we sit a single bench for some time because
My lord. My lord, item number 10 and 11.
yes,
My lord, I am audible.
yes, you are audible, visible both.
My lord, item number 10 and 11, my lord. This is a revenue matter under UTGST Act, my lord. Union Territory of Goods and Service Tax Act, my lord. Learned single bench pass the order. My lord,
Can you move it?
my lord.
Move it on Monday.
They did not serve.
Take the service in the meantime, today itself, you have a counter here.
I have already served, my lord, all the responded, my lord.
I'll assert it. I will assert it.
Also the
Yes. Tomorrow.
My lord
my
is,
lord, can you take the matter on Wednesday, my lord?
Any urgent matter of single bills, then we'll take up that.
no, my lord.
So let us see if one or two matters are there.
Yes, sir. হ্যালো একটু কাইন্ডলি বলবেন হ্যালো 10 and 11 what happened?
Yes, my lord. Lordship has risen up.
Risen, court has risen.
Hello, yes. Operation is success. Patient is
That's no matter. Larger perspective.
Yes. Is any urgent matter you have? Yes. Any urgent matter which requires immediate? Nobody has an urgency in the matter.
No, my lord.
There are a lot of motions. देखो कॉल करो देखिए. Which one? Other, oh,
I informed that one of the party expired.
oh, that is what, you have to make a substitution.
Monday I will intimate her.
You have to make an substitution. Bring it. Have you made an application in the trial court?
No, Lord, my client will not come. Monday I will make the application and.
Anyhow, we can dispose of that. What about the other?
Item number 100.
What is this matter?
They had
COVID was they were
asking
COVID
for-
was- they were given a contractual employment. And after that time, they notice was issued that the person who were given, who worked at the time of COVID will be given different. And the set of contractual was done, but their preference was not taken. They have filed a reply and said that matter is from
What
Monday.
preference?
Those persons who has. worked
In a regular recruitment process, the preference would be given, then what preference? In what sense the preference has to be given?
Okay, it's matter is from Monday notified.
Let it come on Monday. I have no difficulty.
The matter is mentioned by the counsel for the petitioner that there is an urgency. On the ground of urgency, as the persons are unemployed. By consent of parties, let this matter be listed on Monday.
Mellows may not record consent. Consent is not required, Mellows.
What for listing of the matter on Monday?
I have no difficulty with this. Very well, Mellows.
This is the consent for this.
Very
Let this
well.
matter be listed. This is what I says. Nothing more than that.
If possible, otherwise.
Why you are apprehensive? This is only for the purpose of listing of the matter, nothing more than.
My lord. If possible, my lords, I'm requesting will the consent not be recorded. My consent is irrelevant. My lords can always fix a matter.
That is what I know. That-
I may not record my lords consent, my lord.
I
Request.
was recording it for one reason, because the others may come and say. that-
I am ready in every matter, but I don't want my
That is
consent to
what
be recorded.
I say, that
I have
if
no
you,
difficulty.
if you say that, yes.
I am ready to cooperate in every matter, but my consent may not be recorded, my lords. I'm requesting, my lords. Let it not be recorded. Because
What? Then should I say that did not raise an objection?
that is irrelevant, my lords. Even my lords, he's on the basis of his submission, my lord can upgrade. Wow, I am irrelevant, my lord.
In view of that, let this matter be listed on Monday. Under the heading for order.
Most grateful. I'm sorry, my lords. Thank you.
Yes. Fourteen, yes.
My lord, in this matter, I am appearing for respondent and it is my suit for specific performance of contract.
Her client wanted it to be expeditious.
I am very much.
What is the stage?
Stage is for evidence. The examination chief has already been filed.
But the civil power, but that has not been given
Yes.
as yet. Then how the court will proceed? Just tell me. Now I understand. How can he proceed? If the court has not been provided with the power, then what can be done? That we don't know. When he has joined? 18th of? So it's hardly 3-4 days. at least the administration will take some time. So come the next week. No, it can't be done. In the meantime, I am taking up the matter in the administrative side so that if the power is delegated, then there is no difficulty. Any other matters?
There is an order of the court whereby my sister will now approach this court and this court directed to consider the representation and dispose of the matter. My lord, thereafter notices were issued, survey were conducted, but proceeding concluded on 18th of December 2020. Final order is not passed by the deputy commissioner. This is why.
The same deputy commissioner is there.
No, no.
So now how can he pass the order?
So
Because-
proceeding was,
But he has not heard out.
So my lord, let the hearing be given and.
This is what is person. Yes, that can be done.
My lord. Can we dispose of?
The grievance of the petitioner. Write it in a different. The petitioner is aggrieved by an inaction on the part of the deputy commissioner. Deputy commissioner is hearing. Inaction on the part of the respondent number 1 in not concluding the hearing by passing a final order. A writ petition was moved before this court, being WP 147 of 2018 by the sister of the petitioner, sister-in-law of the petitioner, raising a grievance that the representation filed by her has not been attended to nor disposed of by the authorities. Dispute relate to what?
This is with regard to incorporation of name in the license of the land.
The dispute pertains to the mutation of a name, mutation of the name,
License.
mutation of a name in the license issued by the authority in relation to the house situated within Port Blair. The court directed to dispose of the said representation upon giving a notice to all concerned parties within a time frame. The petitioner claimed herself to be one of the interested party, and in fact participated in the hearing upon being served with the notice, and the record would reveal that the hearing was concluded in the year 2020. Till date, the final order has not been passed by the respondent number 1. I am given to understand by the respective councils that the officer who was posted as deputy commissioner at such a relevant point of time is no longer holding the said post, and a new incumbent has joined therein. Since the court directed the hearing to be accorded to all the interested persons in order to secure the disposal of the said representation, the opportunity of giving a hearing to the hearing cannot be cannot be avoided. Since the new incumbent has joined to the said post, and therefore this court feels necessary that the new incumbent must give a notice to the persons who appeared before the erstwhile deputy commissioner and afford an opportunity of hearing to them, and shall dispose of the said representation within 4 weeks from the date of the communication of this order, on the basis of the documents available on the record and the evidence, if any, recorded of the parties on assigning proper reasons.
Time instead of 4 weeks, 8 weeks.
What? Do it. If you can do it in 8 weeks, you can do it in 4 weeks. What is the difficulty?
Oblige, my lord.
Yes. Disposed of. Yes. Any other matter? Which one? 1-3. You are the advocate on record? The advocate on record of the petitioner submits on instruction that his client does not intend to proceed with the instant revisional application and prays for dismissal thereof. In view of the above, the revisional application is dismissed as not pressed. Anything? Any other matter? Nobody?
Bye-bye.